Welcoming you, Vikram.
Thank you, Prajakta, and thank you, Akriti and team at Legal Era. You've been very efficient in setting up this Gen X 2021 conference. It's got some really exciting list of participants. I was sitting through the previous session on competition law, and I think I learned a lot, listening to Shashank, Zamir, and the team. It was, a good learning for me. We are hoping to carry forward a bit of learnings in this sort of next panel on the new labor codes that we've all heard of. And obviously, we've titled it that is it a case of old wine in a new bottle? Um, uh, if you look at it, from the lockdown that began, we and somewhere early like March 2020, we kept hearing stories about doctors and frontline workers working overtime and being right in front to kind of take care of the situation, and they've done a wonderful job. They've been sort of working double hours. I think it's a bit similar for the overall HR community, HR lawyers, employment lawyers like us, in-house counsels whom I have on the panel, compensation and benefit experts, and everybody also has been working a lot in this whole phase. It's been a great learning for us, the lockdown phase, where we've had to deal with questions on how to take care of offices being shut, to shifting to a remote working sort of concept, and then wage reduction, hire and fire kind of issues, delaying joining bonuses, offer letters, postponing sort of retention pays and bonuses. All of those questions started coming up, in this whole thing. And everybody on this panel, I can tell you, has been working a lot in that whole phase. And the phase continued to the second wave, where suddenly the response from employees was completely different, and employers said, how do I take care of my employees and their families, right? It was a really great experience, if I may say so. But in this whole excitement for this whole HR ecosystem came the new labor codes. In September 2020, three labor codes were enacted, and that was after the first labor code, which was enacted in 2019. So we have now 29 national level labor laws being converted to 4 codes. These 4 codes are not yet effective. I want to clarify that, and just so that we are sure. And the effective date, which was expected to be 1st April 2021, has been pushed. It continuously kept getting pushed to July and then October, and now we hear that it might be taken up in 2022. We have a new labor minister, so obviously he needs some time to understand the impact of the labor codes. I think earlier this week I read an article that he is going to be initiating discussions with some of the leading trade unions in terms of how what else can be done to ensure that the labor codes are implemented smoothly. So there is a bit of work that is being done at the government level, both at the national government as well as the state governments, who are going to be coming out with the rules to the labor codes. But I think the point is that it's only a question of if. It's no longer a question of if, but when. It's only a matter of time now, because it's quite certain that the labor codes will be implemented. We just don't know when. And hopefully, if everything goes well from the government's perspective, they are looking to implement it on April 1st, 2022, which is obviously the beginning of the financial year. That's what we are expecting. But again, we don't know. It could be any other time as well, depending on how the government wants to take it forward. We also don't know whether they will go and implement all the 4 labor codes in one shot, whether they will implement certain labor codes on certain dates, or certain provisions of certain labor codes on certain dates. All of that is fluid. We don't really have answers to those questions. But the main question is, are the new labor codes a case of old wine in a new bottle? I'm not going to be answering this question, and it is for the participants here to determine towards the end of our panel what they think about how the whole labor codes have come in. I have some highly experienced speakers joining me today, and we have speakers from various industries, to obviously get different perspectives. We have speakers who are from IT, ITES, retail, pharma. So I think what we are going to be doing is to get and share each other's perspectives on the labor codes. We've got some talking points, but before I start, I will request each of my 5 speakers on the panel today to quickly introduce themselves to you. I will request Abhinav to start, and then followed by Amit, Mansha, Manoj, and Priya.
Well, thank you, Vikram, for having me here, and thank you, Legal Era, for inviting me and giving me this opportunity. I hope you guys can hear me.
Yes.
Yeah, so I had some issues with my system. So a very, very good afternoon to all my co-panelists, and I see that I'm the only HR person in this esteemed panel of all the lawyers. So good afternoon to you, and good afternoon to everyone who's attending this session. Just a quick intro. My name is Abhinav Sinha. I am the Director of Compensation Benefits for Abbott. Abbott globally and in India is a healthcare company, and which we are present in primary 4 segments of business. One is pharmaceuticals, second is nutrition, third is medical devices, and the fourth one is diagnostics. So that's a quick intro for of my employer. I'm really happy to be here. Really happy to sort of have discussions with all of you, and looking forward to some exciting and enriching discussions.
Thanks, Abhinav. Thanks, Legal Era, and thanks, Vikram, for the introduction. Yeah, just a quick intro from my side. My name is Amit Shinde. I am General Manager Legal at Mindtree, and I lead the commercial transactions and the dispute and litigation portfolio. A bit about Mindtree. Mindtree is a provider of information technology services and is engaged in the business of IT services, particularly in relation to software application, infrastructure management, and technical support, software product engineering, etc. Yeah, I look forward to having a good discussion here. Thank you.
Hi, good evening, everyone. This is Mansha. Thanks, Vikram and Legal Era, for extending the invitation to this esteemed discussion. I head the legal for Airbnb India and Airbnb Global Capability Center. I've recently joined Airbnb. And as part of my job, I head the Global Capability Center. From employment perspective, is the second largest employee base for Airbnb in the world. It's rapidly growing, has a lot of workman category and workers who are contingent that are part of this entity. So this conversation becomes really relevant from that perspective as well. Before I joined Airbnb, I was the head of legal South Asia for Discovery Networks. Thanks a lot for extending this invitation, and look forward to this discussion.
Namaste, good evening. I'm Priya, Ananthan. Thank you, Vikram. Thank you, Legal Era, to have invited me today. I head the employment legal department at PNY Mellon, which has over 14,000 employees in India. It is within the financial sector, set up as an ITE as in India. And I am a qualified company secretary and a law graduate, having over 24 years of work experience, predominantly in the financial sector. I'm really looking forward to this wonderful session with my esteemed panelists. Thank you.
Hi, I'm Manoj. I head the labor employment of the company which is being bashed recently by the previous panelists. That's Amazon. So I've got a lot of visibility even prior to this session. So I'm the lighter wing. Yeah, we deserve a lot of good visibility in every sphere. I head the labor employment side. We support close to little more than 100,000 employees. I'm talking about the permanent employees, and like what Mansha said, a huge number of contingent workers, which are the numbers which I won't be able to share because it keeps changing from peak to peak. I liked somebody saying, the HR person saying that I'm the only HR one here, the compensation benefit. I hope I had the best of friends from the compensation benefit, because they're the ones who pay the money, and we are the ones who spend it. So one more hope is this is not a case of old wine in new bottle. I hope the government really understands that we really need to work towards beating the dragon, which is across the border, and we need to come with very innovative new policies, huge reforms. We have suggested few of them as a company and part of the industry body of CII. And if this country needs to progress towards becoming a large economic power, we need to think beyond, out of the box. And I surely feel it shouldn't be old wine in new bottle. Let's have some fresh wine coming out of new bottle as such. Thank you.
Thanks, Manoj, and we'll come to that in a moment. And well said on Abhinav. I mean, that was also the reason I decided to have him first to introduce himself. You know how important comp and benefit is to all of us. So let's move directly onto our topics. And maybe Mansha and Manoj, I will request you to start in terms of giving your perspective on the new labor codes. How is it going to impact hiring and firing? I mean, just generally, what's your analysis? How do you see the labor codes coming up? Just wanted to get that given your large size of operations.
So should I go first, Mansha? Because we do that very often. The first part and the
Please
second
go ahead. Please go ahead.
So first of all, I don't want to use the word firing because I would say termination employment. So firing is a bad term, even though we keep doing it. So let's say termination employment. So the new labor codes, for that matter, I would say it's old wine in new bottle as far as we have been talking about hiring and firing. Let's think about hiring. We have to be smart. The courts have given us certain, I won't say that the courts and the draft rules have given certain leeways of getting new employment models. Like a few years back, we didn't have anything other than permanent employees. Then we had this Badli and all those stuff. Then we came with contingent labor when we had the IT companies coming in. I'm talking about the era of 1970s and 80s. Then we had the contingent labor coming in. We had the CLRA provisions, which was very restrictive, what you can do, core. I know there's somebody who's going to speak on the subject of core employment also. So if we are doing hiring now, we have to think about different models of employment first. We could think about FTC, which the government, the law says FTE, which is fixed term employment, which talks about a specific period and you have a start date and end date happening. So the old idea of having permanency of job, I think, is going away a little bit. We need to think about hiring part-timers. We like, especially companies where you have Airbnb, Ola, the Ubers of this world, because the flexibility of work is so much. You need to understand there could be peaks, there should be sudden ups and downs. So we need to have people, resources to support it. In such a case, you can't have a permanent workforce of huge numbers because you're not sure whether that's enough or is that more than enough. So we'll have to look at hiring people in different models as such. And again, numbers, the contingent labor, when you bring in numbers, we will have to look at what are the best methods of doing it. We also need to be smart enough to understand that we better pay good salary compensation that's when we look at the HR and compensation person. And so I'm not talking about the manager category, but for the associate population, the one at the lowest level, when you're talking workers, we need to think about that group of people. When I think about hiring, so then you have the core subject, you have a core, can we bring the contingent workers into our core employment? Now the new codes have been made it slightly restrictive. They're making a statement by saying that you cannot employ contract labor in core. Then where can you employ them? Because most of the companies, let's be very honest about it, we all have work to be done by our people. Most of the work which we do is mostly core to our business. So when do you bring contract labor? All this while we were clear that contract labor could be brought in for even core if it's temporary in nature, if the work is seasonal, not perennial in nature. Now by putting a spoke in the wheel, by saying that it's core, you can't have contract labor, they emboldening the regulators, the inspectors to come and inspect and do that. So when you hire, they're going to restriction on hiring, or there is a perception that you cannot hire these kind of people. We will have to look at it beyond that. We should look at hiring people for short-term contracts, FTCs, even thinking about a 4 and 5 day work. We already have 5-day work in ITS, but we could even think about a 4-day work also. I understand Europe and Australia is thinking about a 4-day work on 3 days of off. So we could look at all this at the same time, increase the number of hours of work, without impacting the spread over. That's the kind of hiring we should look at. When we talk about firing, I would say termination employment. That's a little bit of an issue. Now, this is part of work. It's one of the cons of our work, where we will have to do this because we have the bell curve. We want to raise the bar. We have the performance issue. When I think going forward, we have to be very careful while we do termination. We have retrenchment, which is basically a closure of business or closure of a certain kind of job or something. But I won't go into that because that's a clear understanding. There's hardly anybody who doesn't know it. But when we talk about normal performance-based termination, we should be very clear that we have given enough feedback. We have made the right call. Let's say we're going for a disciplinary termination. Do we have the right investigation method? Have we followed the process? These are things which we will have to be very cognizant of. The new the IR code and the standing orders have defined that you can do this. They have not spoken about domestic inquiry. Look, domestic inquiry is an anathema for any IT and ITS person. If you talk about manufacturing sector, they have been doing it for so many years. But if you start a domestic inquiry, it's like you don't know when it's going to start and when it's going to end. So none of us want it. In fact, you speak to any legal person from an IT company and say, we want an exception from the standing order. Why? Because there are restrictions. One is the domestic inquiry and all that stuff. The new standing order, at least the draft, I've seen the draft standing order from the Joint Secretary's office. It has provided us certain benefits. What they're saying is you need to do an investigation, provide the opportunity of audio alteram partem, principle of natural justice to be applied. So they have not said that you have to do it this way. But having said this, they said you should be giving an opportunity for the person to bring in a friend to defend his case and all that. So while we do firing, we'll have to be careful while doing that, especially the associate population, which is the worker class. We don't have at will employment in India, even though most of our employment contracts say that with 1 month notice, I can terminate. We continue doing it at the risk of being called up or hauled up before the labor courts. But going forward, we have to be much more careful, a very documented process. We have also encountered these problems, but we've been able to prevail upon the inspectors and tell them that this is the process we have followed. Yes, probably we have not followed domestic inquiry, but we have given adequate opportunity for that person to come and state his side of the case. And then we have fired it. Even when we do performance management and termination, we need to have a very consistent process. That's where my HR, without any, this thing to my friend here, the HR population need to be understanding that they cannot do something at the whims and fancies. They should have proper documentation. When we finally do the termination part, we should have enough justification for doing that. It should not be, show me the face and I show you the rules. So I'll stop here and allow Mansha to pitch in with her views.
Thank you. I think I definitely agree with your views on ways of working, how that has to really change in terms of hiring and firing, and where the law really now falls short on certain aspects. I mean, when I look at it, I certainly do have the same view, where I do see this as a old wine in the same bottle, but it does subsume 29 central laws and aims to sort of amalgamate various legislation, simplify, rationalize provisions of subsumed laws, etc. But it also, in some form, increases and makes the compliances cumbersome, increases cost to the employer from an employer perspective. It does have certain aspects that are conducive for employers, not just employees. For example, it does streamlines and simplifies the registration process, makes it centralized, makes certain aspects electronic to keep the record electronic, etc. From an employer perspective, But I think a lot has to really needs to be clarified, and we hope that is done through rules and draft rules whenever that is notified. But just as an example, in case, as you mentioned, that the gig workers cannot be, there is a bar for them to be engaged in core activities, but that does also have certain broader exemptions provided. Now, as far as we are concerned, we feel that we could make a do with those broader exemptions because they are, not really very restrictive, so to speak. But there are certain aspects that need further clarifications in terms of, certain extensions of protections from social security perspective to gig workers. There are provisions around leave encashments, for example, or full and final settlements that we are going to speak on later. These are the aspects which we feel require more clarifications. This, for example, the definition of wages will now make companies restructure the entire ways of functioning and the structure of wages. The employers will need to restructure the way their leave structure, for example. This is going to be an increased cost to companies as well as cost of compliance. So I honestly, do see a lot of positives in it for the fact that it does sort of is progressive in terms of simplifying the structure and making it, and in a long term, perhaps there will be an ease of doing business, but I think a lot needs to further be threshed out and clarified through draft rules, and we hope that that really happens and government really focuses on that through a consultative process if possible.
Yeah, thank you. And some of the points you discussed, we will obviously be taking on today. You did mention about the new wage definition, and obviously that's been the single most or the biggest impact that the labor codes are going to be bringing. And maybe this is the right time to discuss that. Maybe I will have Abhinav, who's obviously closely following each and every word of that definition and possibly has it by heart now. And maybe also request Priya and Amit to share their views on the wage definition.
Sure, Vikram. So definitely, I mean, by heart, but I'm not going to, sort of, going to parrot that around. Certainly, I heard a couple of panelists mentioning it's the case of old wine in an old bottle, but specifically looking at the code on wages, my personal view is that it's a new wine, more refined, more refurbished, and more consistent. And in a new bottle, and the entire package is expensive. So it's an expensive piece of wine, if you ask me. So I mean that's my opening statement. But let me sort of get into the definition of wage per se. We've had multiple definition of wages. We used to have previous to the wage code, but what this wage code at least does is that it makes it consistent. And I'll not get into the brass tacks of it, but I just want to talk about a couple of things which it's introducing. So it's apart from that, I mean, I think it's introducing the concept of total remuneration. Doesn't define it, but introduces it, right? So that's point one. Point two is it's also introducing the concept of in-kind benefits. Doesn't define it, but again introduce it. It leaves it at that, right? And now you've got to the entire the legal fraternity, the HR fraternity. I mean we get into in terms of just decoding it, what it means. So the new, I mean, the way I look at it, and these are my personal views, absolutely not, what my employer thinks. But again, you need to look at the entire, you need to define the entire universe of total remuneration. So you'll have cash compensation, you'll have, the exclusions, you'll have the in-kind benefits into that, right? And then, what you look at is that you look at the exclusions, and then you take a percentage of that exclusions of the total remuneration. So and I'll say, I mean, where it sort of slightly makes it complicated. So when the exclusions become more than 50% of the total rem, you add the additional amount back to the wages, right? So that's step one. It would have been really great that had the law defined it. Point two is that now when you look at the in-kind benefits and you define the in-kind benefits, then you take that as a percentage of the wage, not the percentage of the total RIM, but you take the percentage of the wage and say up to 15%, I'm going to again add it back to the wages, right? So what it is doing is that while it is making things consistent across a broad brush of labor laws that we have, it's slightly also making a complicated calculation which the HR departments or the comp departments across the organization will have to do line by line for remittance of retirement and other benefits which is going to be there. So that adds cost, that adds the pressure on developing those systems. So all the downstream effect is going to play out in future. So that's what my take is. Certainly makes things consistent, but complicates it from an employer perspective, does add costs. And yes, I mean, it makes slightly lives more complicated for people who work in MNCs, because it's complex. You have to make it simple, and across the globe you have to make people understand, your stakeholders understand in terms of what you are about to do is the right thing to do or not.
Priya?
Sure. And as I'm hearing our expert panel discuss it, the only thought that I'm having today, when we look at labor codes, it took us, a 1952, EPF, the Provident Fund Act, and there was this Supreme Court judgment that came out after 56 years in 2018, which finally looked like it was the last nail on the coffin, which reiterated that, look, organizations, you've been thinking all wrong. The law that was there in 1952 was indeed the law. And I think it's on a similar footing that when we are recognizing and realizing these provisions that are creeping into the labor codes, which are seeming to be new, I guess it will take us a while as a country to also age into the new norm, and the debates will continue, and there will be, I'm sure, judicial precedents where the interpretation can be subject to case laws, and how we are really talking about components like performance bonuses and other components where, like my colleague mentioned about being in kind, and what will really fall within the scanner, what will not really fall within the scanner. And I think risk-averse organizations will definitely ensure that they take a more kind of a conservative view rather than a liberal view, or some would prefer to wait and watch. So what would be interesting is also to see how, as an organization, we are also able to influence eventually, especially the slight politics that will play here, given that this is a federal law and there are state governments. And as an ITES today, I do enjoy certain benefits. I do have certain exemptions from certain provisions of the Shops and Establishments Act, which seem to be a lot more beneficial to me currently as compared to the impending labor codes. So it would be very interesting to also see how the state governments are able to also patronize their agendas and how they would want to cater to this unique service industry. And I would be eagerly waiting and watching, and of course, like I said, how we are able to influence in the whole scheme of things.
Thanks, Priya. Thanks, Abhinav. I think very interesting views you shared. I think I have a view here that amongst all the codes which we are looking at, this is one of the code, or this is one of the definitions which is invoking a lot of interest, curiosity, anxiety amongst the employees in terms of how it will be structured, what would be the implications of that. Several questions and several. It has invoked a lot of curiosity, I would say. And the intention definitely seems to rationalize and standardize, the definition of wages for all the codes. The aim seems to be to make it uniform and wider as compared to the existing definitions, and very definitions under the existing regulations, I would say. And it's commonly, it doesn't make a distinction between the establishments, and it also, there are certain good things from the employee perspective as well. If you talk about the time for preparing the claims, or the need for making the payments within the prescribed dates, all of those are concerned. Definitely, that would be beneficial to the employees. Is what I feel. Yes, there would be challenges definitely in terms of how it would uh, play out in terms of the retirals, or the gratuity contributions or PF contributions, and it will definitely have impact on those aspects. Is what I feel. One important aspect I would like to mention is about having this national floor wage of minimum, a fixation of the national floor wage. Now, that is something which I feel is one of the important aspect of this definition, or which would be related to this definition. The central government definitely will. Central government intends to consult the central advisory board, the state governments in fixing national wage. And one aspect which I feel would make it uniform at the national level is that if a state is already having a rate more than the national floor wage, it cannot reduce it to bring it at par, which I see to be more employee friendly. So these are the key takeaways. In terms of the challenges, as I said, yes, it will have challenges in terms of assessing how the gratuity or how the retirals would be fixed, and how it would be structured. But that's for the larger debate. I believe that many industry uh, participants or representatives have made representations to the government in terms of modifying the rules or coming up with clarity on the rules, I would say. So that is still, it'll be interesting to see how the rules come about, and if at all we see any changes or any modifications in the rules from the definition of the wages perspective.
Yeah, thank you all. Interesting views, and again, we appreciate that it is almost impossible for any government to change a labor law, especially in a populated and labor-intensive country like India. And I think this government has done a massive work of consolidating 29 national level labor laws. So obviously, congratulations to them on taking this up, right? Nobody really wanted to do it. And it's not the first time we are talking of consolidation of labor laws. This whole idea came into existence almost 20 years back. But finally, we've seen that, and it's almost on the horizon now if you look at it. So it is difficult, but they've done it. There are challenges. But at least in the next part of our discussions, I have requested each of my panelists to pick up one or two interesting new concepts that are being brought into by the labor codes, something that wasn't there previously, and now we are seeing it. Maybe I will have Manoj start on an interesting concept that he came across in this new labor code, and how the impact of that concept will be. Manoj, if you can speak for about 3-4 minutes. We are already running short of time. We have about less than 20 minutes now.
Yeah, you guessed it right that I take a lot of time when speaking, but I'll do it fast. So let's, Mansha touched upon the point of gig workers. So we when world over, Amazon is touted to be one of the biggest gig worker platform or company across the globe. So what is gig? When we think about gig, we think about a circus. So it's more like we are doing a circus while doing our business. Sometimes I feel, yeah, probably that's the right word or coined to name these kind of people. And like what Vikram said and the other panelists said, this government has actually put forward a big job, or a yeoman work of consolidating the labor codes. The second part is the most important part, where I feel companies like us have a clarity and consistent approach, is defining a gig worker and making a law where a social security kind of a scheme is provided for them. So if you look at what is a gig worker is somebody who's doing work in an unorganized sector. So they have defined gig worker as a person who performs work or participates in a work arrangement and earns from such activities outside of a traditional employer-employee relation. So it's mainly a what you call contract for service kind of stuff. But when you do a contract for service, is every contract for service a gig worker? I don't think. These are mainly the government has brought these people into a framework where there are people who are on contract, and it's an unorganized kind of sector, probably a BD worker, probably including, I would say, you had that what you call the building and other construction workers. The government decided to come out with a law called or a fund called the BOCW. So similarly, they are thinking about a gig worker fund. So I don't think any other country except California is the only state which has defined what a gig worker is, what could be done, and what is the kind of support you can provide. Now, having a gig worker, what is the benefit, or what is the benefit of having a definition and a classification as gig worker? Now, all this while we've been bringing people on board as contractors, doing work which is core to our work, like let's say deliveries, core to my kind of business. There's huge risk of misclassification, which has always been there. Like Mansha said, for her, she has contingent workers who support her, or even contractors who support her. They all could be considered as doing something which is core to their business. So we were always working on a premise that there will be a day when some inspectors, some regulator will say, these are all doing your core work. They are doing work, which is very connected to your kind of business. Please take them on board as your. They won't say even please take them as your permanent employees. But companies like us will find it difficult to have all these people in our on board. Like I started off saying that we need a huge number of people for spikes and peaks. So it is very important for us to have flexibility of labor. This gig worker, now having said this, we always been supportive of this kind of people. Even in US, you have the $15 per hour, which Amazon pays at least $4 to $5 above the legally required minimum wages. Here also in India also, we have been supporting our gig workers, which is the delivery boys, by providing them with now during this period free vaccination testing, providing with whatever benefits we could do. We also provide insurance and other cover. But once this happens, or the gig fund happens, it kind of mandates an employer who, or we call it aggregator. In fact, they've given a definition of aggregator also, to pay an X amount of money into a fund, which will take care of all the gig workers. Now, how is this fund being managed is a big question mark. We don't know about it. The government also is reaching out to organizations like us, saying that we have come out with this law, we have come out with this particular provision, but how do you manage it? So they are also still searching in the dark, but I'm sure they will come out with something, because I don't think they should go in the way of BOCW, where it's a black hole. Every company pays a percentage of the construction cost to that fund, and what I heard is almost 40,000 crores is lying in that fund with nobody claiming it, because people don't know that there is a social security fund which has been meant for me, and because that kind of work is very unorganized. Here we are going to, so they give two options to come. So you have an option of either paying 1% of the total turnover of the company, or 5% of the contract charges, which is paid to the gig worker. So the company has an option of choosing whichever is the lower. So every year they don't say that you can't change it from year to year. So they give you the benefit, or you have the leeway of deciding whether you want to pay the 1% of the total turnover or this. Having said this,
so
also,
Manoj, I'll have to stop you.
Sorry.
We have others also talking about their interesting concepts. Priya, would you like to chip in terms of the new concepts?
Sure. I would want to say that there are certain noble provisions that have crept into the labor code, One such thing is the ever debated work from home. And there is a reference under the standing orders OSH code where there is a mention about work from home. But again, I think the interplay of politics, again, how the state governments want to view and what's their agenda around the IT park. I recently reviewed a draft IT policy of the Maharashtra government, and I could see that the entire impetus of that draft report was to set up brick and mortar IT parks across the districts in Maharashtra. They wanted to generate employment. They wanted to obviously give employment to the local people. And to me, then it's kind of looking that it will directly clash with the whole concept of work from home, remotely working from anywhere in India, which kind of then probably undermines some of the state government agendas of giving employment to local youths. So things like that, I think that we as organizations, we may get caught up in such abnormalities as we progress. But until then, I think we just want to imbibe whatever has been offered and work around it. I'm sure we'll come up with innovative solutions on how to restructure our comms. So, both the employer and the employees are happy eventually. And I know there has been a lot of furor in reduced work take-home pay because of the increased or the change in the definition of wages. And those are issues I'm sure the government would want to address eventually, and how the trade unions are also looking at the 50% cap on the exclusions. And it would be interesting to see how these would really pan out when eventually the codes get enacted.
Thank you. Mansha, what's your view about the new concepts?
So one of the things that, that we are, of course, examining and which wasn't present in the Payment of Wages Act of 1936 was the fact that it now defines the timelines within which full and final settlement have to be paid by the employers in case of resignation of employees. Now that includes a timeline of 2 days from the date of resignation that the employer has to make the full and final payments. This is what needs to be seen, and we hope in the draft rules or the rules whenever those are notified, because the provisions also mentions that the appropriate government may provide any other time limit for payment of wages where it considers reasonable, having regard to the circumstances under which the wages are to be paid. So there may be scenarios where it is not possible for employers to make payments within the 2 days. There may be scenarios where a particular resignation happens with immediate effect in cases where assets are not returned within 2 days. The tax documents are not furnished to the employer within sufficient time. So I think we are currently going to just wait and watch and see how this really pans out the moment that this is notified. But certainly this is something that is going to have a huge impact on the ways of functioning, and how we are really going to allocate resources, and also ensure compliance within these 2 days of no dues of full and final settlements in case of any resignation. Another concept that sort of draws my attention was the fact that the fact that a worker can demand encashment of leave at the end of every calendar year. What's really interesting to be seen is, what constitutes the definition of, or who would fall within the definition of worker. Because, the definition of worker itself, it excludes, for example, anybody who is mainly into a managerial or administrative capacity. Now, what would constitute an administrative capacity is something that is to be seen. Also, once this is really notified, we will have to see and really figure out who would really fall within the definition of worker and who would not. But this section 32 of the Occupational Safety, Health and Working Conditions Code of 2020 makes it, provides for a provision where every worker is entitled to demand encashment of their leave, unutilized leave, and at the end of every calendar year, which means that this again increases from employers' perspective a whole lot of work in terms of and cost to ensure that they meet these demands if these are requested for by any worker. Of course, this sort of provides for unutilized use. So anything that cannot be carried forwards, and there is a limitation there of 30 days, the 30 days of leave that can be carried forward. Anything that cannot, workers have the right to demand encashment of it. So I think these are certainly the new concepts that have been introduced in the new labor codes, the two different labor codes that we just spoke about. And we will actually have to wait and see how these are implemented by the employers. We're not going to be the first ones to try our hands on. And we are also going to see, if how this actually is taken by, as Priya rightly mentioned, by different states. Because in case of leave, or leave encashment, there are state rules. Even in case of carry forward of leave, the state of Maharashtra has 45 days of leaves that can be carried forward, for example. So we'll have to actually see how these are really implemented or by different companies, and how these are really taken in different states. So, yeah.
Thank you. Amit, would you like to go next?
Yeah, sure. I will. So one of the interesting concepts which was perhaps part of the state act is now creeping into the central act. Now this is about the negotiating union or negotiating council. And in terms of recognition of trade unions, only the state of Maharashtra, there was a specific legislation, the Maharashtra Recognition of Trade Unions and Prevention of Unfair Labor Practices Act, which now is making its way into the Central Act in the form of Industrial Relations Code. This section 14 of the code, the Industrial Relations Code, provides for negotiating union and negotiating council in every establishment where there's a registered trade union, and it lays down the parameters for that. If there's only one trade union which is registered, where all the workers are registered, the employer shall recognize such trade union as the sole negotiating union of the workers. In case there are more than one trade union workers registered, then the employer will have to recognize the union which has more than 51% or more members enrolled with it. And if there's no, clear majority in that case, then I think the employer will have to constitute a council, consisting of representatives from various trade unions having more than 20% of employees as their enrolled members. So it's a very important concept, which is, I believe, it's creeping into, or it's stepping up into the national legislation or the central legislation.
Thank you. And Abhinav, back to your favorite topic these days on wages. There are some new concepts there. Would you like to talk about those?
Sure, Vikram. I'm cognizant of time as well, but yes, I mean, the remuneration in kind, which is in kind benefits, again, is a new topic. Certainly, in a lot of unorganized sectors, there was a prevalence of payment in kind, right? I mean, a lot of benefits people gave in kind, and certainly the intent of the government is to ask employers to account for not what you are paying in cash, but also what you are paying in kind. And that's where I think these are two important concepts: in kind benefits and the total remuneration, which sort of is, I think, the step in the right direction, because the law is asking you to account for everything what you are providing, and certainly going forward, putting in-kind benefits up to 15% of wages, adding it back to the wages. This concept is new, yet I think it is going to be consistent with a lot of unorganized sectors wherein the in-kind payments were not accounted for. So I think it's a step in right direction. My only point has been on this entire thing that, if there was any more clarity provided in the law, it would have been slightly more better for all the professionals, all the legal experts and the HR professionals to sort of sort this out, quickly and in the right manner. But yes, I mean, I think those are some things which we'll watch out as the codes come into play at a future point in time. But so yeah, that's what I just wanted to talk about, and pretty much cognizant of the time that we have.
Thank you so much. And yeah, I think there is a risk like stock options and those kind of benefits. How are they going to be treated from the wage definition and remuneration kind? I think we are already through with our time. We have a minute or two left. Maybe I'll just have everyone on the panels just just a sort of parting words, one or two lines in terms of a forward-looking statement on how they are looking forward to the labor codes. Maybe let's start with Abhinav again, just in terms of that one statement of how ready you are.
Sure. So Vikram, I mean, I think I'll take a pretty balanced view. I think the intent is right. The intent is to be consistent and provide a consistent, standardized definition, which is right. On the cost side, it is impacting organizations, yes. But I do look forward, once the implementation comes in terms of how others are going to implement it, because certainly it's going to make life certainly simpler once you've understood the entire gamut of it. So look forward to once the implementation comes in.
Amit?
Sure. So definitely these seem to be in a progressive direction of standardization across the country. Now, the way it would be, way the rules would shape up, the way the implementation would happen, I think that's something which we would look forward to and see.
Yeah, thank you. Mansha?
I think I agree on one aspect that this does seem to be a step in the right direction. Now, the how or when is something that we all of us have to figure out as companies and as employers. I really hope that this will have a long-term positive impact on the industry and would sort of contribute towards some form of ease of doing business for industries and companies put together. So yeah, I mean, that would be my parting comment.
Yeah, definitely. I think it will. Priya?
Sure. As they say, Rome was not built in a day. So I am positive that we will undergo the rigor and we'll emerge successful. And I think we should also remember the whole concept of labor code started off with improving India's ranking in terms of ease of doing business. So I'm sure the government has the right mindset in the whole approach, and they will be supportive to the requirements of as they say, both parties, the organizations as well as the employees. So looking forward to this.
Sure. Manoj?
Yeah, I would like to take this we, them, and off the table. It should be all of us. So I would like the employees, the employer, and the government to work together, a seamless kind of work partnership to take this forward. Because unless everybody comes together, and that's the only way we can. There's an old saying. United we stand, strong we are. Otherwise, we'll not be able to reach, touch the sky. So that's something which I'm looking forward. People to understand that the employer is very important for the employee. The employee is the most important resource for the employer. And then the government needs both these groups. So it has to be a seamless partnership. That's how I'm looking at it.
Yeah, well said, everyone. And yeah, I think there will be a bit of conflict and challenges, and we will see a bit of litigation around that, but I think it's all for a good reason. With that note on positivity, I'm going to hand it over back to the Legal Era team. Prajakta and Akriti, thank you so much.
Thank you to our panelists for that highly impactful and enriching session. Thank you for sharing your anecdotes, your valuable takeaways, and for giving your valuable time and gracing this very occasion. I think all of them have done phenomenal in this session with a lot of thought-provoking ideas that we look forward to imbibe. Let's give them a virtual round of applause for doing absolutely amazing and adding so much of value. Thank you.